Thank you, Ms. LePink. Appreciate your testimony and for appearing here today. And I think that certainly goes without saying. I know from my part of the world, I come from a rural area, ag communities, that we all want to make sure that our children are safe. However, I think that there are some concerns that recognize, and now that there seems to be a repositioning here by DOL in terms of submitting the ruling. You said that it was going to be resubmitted for the parental exemption, and input from agricultural producers played a significant part in this decision. May have a couple of points to this, but what sort of outreach did you do before the proposed rule was coming out? I think one of the great amounts of frustration, which many of us who are not career politicians have, is we see rules and regulations coming out without outreach, and then we feel the impacts. What outreach was done before, and now what's changed so dramatically that now we're listening to the input?
Well, first of all, the whole purpose of a proposed rule and the opportunity for comment, which we extended for an additional 30 days, is in fact to get that input when the actual regulation is out in the public and people know exactly what it is that we're proposing. The whole idea of a notice and comment period is for us to, and we received 10,000 comments on this rule, is for us to be able to take in those comments and consider them and make sure that the rule takes them into consideration when it's become final. So therefore, the whole comment period is, when we propose a rule, it's by no means final. The rule is proposed for the very purpose of engaging the public in what that final rule will be. However, what we did prior to noticing the rule was actually, this rule has been under consideration for a very long period of time. Our GAO report was issued in the late 90s, criticizing the Department for not having looked at these hazardous orders for a very long period of time. So we commissioned a study by the National Institute of Occupational Safety and Health to help us evaluate how things had changed in agriculture, and what potential changes needed to be made in the hazardous orders. They issued their report in 2002. After that report was issued, we engaged with the farm community, farm employers, advocacy groups, and other academians and medical experts regarding what was put out in that report. And then basically nothing happened for several years. When this administration began, we began to look at that report, because one of the objectives of the administration was to update and to look carefully at those hazardous orders to be certain that they were responsive to what was going on for children when they were working. We updated the non-ag rules and completed that rulemaking in May of 2010. So then when we completed that rulemaking, we began the process of looking at the agricultural hazardous occupations. In that process, we also brought in members of the community, including the National Council of Agricultural Employers and the American Farm Bureau, to engage in a conversation about basically what was in that NIOSH report and the other subsequent feedback that we had received on those recommendations. And so it was with that input and the input of others that we then put out the proposed rule. We extended the notice of comment period additional 30 days because we heard from Congress and others that additional time was important to ensure that all voices were heard.
Okay, thank you. You know, I'd like to point out this article I had from yesterday's Durango Herald, which is in my district. It's one of my local newspapers. In the article, it states that for most farmers, tractors no longer earn their keep. Basically, that over the lifespan of the tractor, the food the tractor nets no longer nets enough money to be able to pay for the tractor before it needs to be replaced. Additionally, several other factors force farmers to have another full-time job. Given these circumstances, folks are becoming more and more reluctant to take up farming as a career. I'm fearful that the provisions in the original proposed rule only exacerbate this situation. Can you provide us with any certainty or a sense of hope that these farmers who are becoming more and more discouraged are going to be able to do something that I noted in my opening comments? Family farming is literally family farming.
I understand that. I grew up in a rural community in Minnesota. My father was a family doc. We moved to that community because of the values that community had. So I understand, what it means to grow up in a small town. What I want to make clear is that what we're not doing today, what we're not talking about today, so that we can make sure that we're focused on what we really are talking about. We're not talking about kids who are 16 years and older who are employed on any farm, whether a family farm or a big corporate farm. We're not talking about farm kids who are working for their parents or a person standing in the place of the parent on a farm operated by that parent but maybe not owned, or a farm owned by that parent, and now, as of the announcement yesterday, a farm substantially owned by that parent, so no longer requiring that it be wholly owned by that parent. We're not talking about neighbors helping neighbors in need. We're not talking about kids participating in 4-H or FFA. We strongly support those programs in our country.
If I could interrupt you just
Yes.
a little bit, when you're talking about in need, in my area we have grandparents, great-grandparents, and the family farm. They may not be adjacent. We have neighbors, and you say in need. I'm not sure what in need actually means. And given the nature, you said you grew up in a rural community. I was bucking bales when I was 12 years old, not effectively because they were 80-pound bales.
For your parents? For your parents?
No, it was actually for another farm.
Okay.
And was out and working.
Okay.
And great experience to be able to not only to be able to earn wages, but to be able to learn a work ethic. My father felt that was important for me.
Well, first of all, I don't think that the rule we're proposing would have precluded you from bucking hay. So
I was earning a wage.
I know, but this regulation only focuses on the most hazardous occupations. So even if you are under 16, there are many, many things that you can do on a farm. This does not outright prohibit kids from 15, 14, 13, 12, and younger from working on a farm. It only focuses on those jobs that, based on data, based on our enforcement experience, we have found results in the serious injury or the fatality of children. So bucking hay, to be honest with you, I haven't ever bucked hay, but maybe you can describe it for me, but if what I understand it, that would not be prohibited by this rule.
Yeah, I did, yeah. Actually, Congressman Kritz pointed out, we had a moving hay wagon in front. And I actually got to drive the tractor at 12 as well. And so it's just part of the experience. I guess my point is that understanding, you said you'd reached out to the Farm Bureau. My Farm Bureau has talked to me. They want their children to be able to learn this value. And under the proposed rule of government's here to help, and you've got to be enrolled in a VOTEC program if you're under 15 to be able to participate and be able to work with some of the mechanized equipment. Isn't this a heavy hand of government? We want to be able to, I would submit that our parents and grandparents love those kids. They want to be able to protect them. Do we need the federal government? Do we need OSHA stepping into the workplace of the family farm to be able to deal with that?
Chairman, we have received significant comments on the various, things that you are stating. That is one of the reasons why we made the decision to repropose the parental exemption, because really what you're talking about, the opportunity to work for grandparents and aunts and uncles, is exactly what the parental exemption is what the conversation we're having about the parental exemption is about. And so consequently, one of the reasons that the agency reproposed the parental exemption is so that we would be in a position to address the very issues that you're and concerns that you're raising.
I guess I'd like to move on. I want to make sure
Sure.
we get to our other panel members here as well. But can you explain the discrepancy for me between what the DOL states in its initial rule and what it is currently made publicly available?
Okay. The proposed rule set out what was the current enforcement practice of the agency, which our enforcement records indicate dates back to approximately 2002. The FOH that is on the website is out of date. When this rule was published, we were in a comprehensive revision of that chapter, in part because of outdated provisions like the parental exemption, but also because of the recent amendments to the child labor regulation that went into effect in 2010.
When was that language changed?
When was the language changed? The language in the FOH is out of date, so it hasn't been changed. But the enforcement practice of requiring that the farm be wholly owned began in 2002.
Okay.
At the latest.
Has this been enforced?
Yes.
Okay.
Yes, we have. I mean, we don't have regular cases on, in terms of family farms, but we have our enforcement data indicates that as early as 2002, the issue of whether the farm was wholly owned or not for purposes of a citation was an issue.
Would it be possible to get that enforcement data from you?
Yes.
Okay, we would appreciate that. Would like to follow up a little bit on some of your earlier comments there in regards to the field operating manual, and which when you stated that it was wrong. When did DOL update it, and when was the record of those updates?
Well, the department has been in the process of doing a comprehensive update of the child labor chapter that was driven by a variety of both regulatory and statutory changes and interpretations. I mean, one was the passage of the GINA law that increased the penalties that the Wage and Hour Division is to issue in certain kinds of situations where children are killed and injured. We were also updating them for purposes of the 2010 amendments to the non-ag child labor. But that chapter had not been updated in many years. And so consequently, it's very difficult to keep. The FOH, first of all, is an internal field operations handbook. Its primary purpose is to guide my field in their enforcement of the law. So consequently, however, every time the law changes, every time a court decision comes down, every time a regulation changes, there's a need to update those FOH chapters. There are many of them, and they cover, my agency enforces 7 major statutes. So as a consequence, we are continuously in an updating or a need to update the FOH, the Field Operations Handbook. So as a consequence, sometimes those updates are delayed. However, the FOH is primarily on the website because we get frequent FOIA requests for the public portions of that document. And so in order to expedite the public's access to that frequently requested information, we simply put it up on the website so that we can simply direct people to the website as opposed to having them go through a FOIA process to get that information. So consequently, we're always in a balancing game of, do we make the information available even though all of it might not be up to date? So for example, the FOH that's up on the website now does not have any reference to the May 2010 amendments to the child labor regulations because we were in the process of updating the entire chapter in addition to add those in addition to many other changes. So consequently, this is a continuous process that we're engaged in.
So we've almost got a situation to where the people are hearing one thing, the enforcement's doing something else, and there isn't great coordination going on.
Well, the agency has significant guidance that is actually the guidance that we direct the public to in the form of fact sheets and field assistant bulletins and interpretations and opinion letters. that are the formal interpretations of the agency that and regs, regulations, and of course the statute, are the prime sources for people to know what the law requires. As I said, the Field Operations Handbook is primarily written to guide my field. So, but policies change, laws change, regulations change, and I have done my best since I've started to proactively get those chapters that are out of date, that languished prior to 2009 and were not updated. I have been working as hard as I can to get those chapters updated because I know the importance of that information, being current to the extent that the public would look to that document for guidance.
Yeah. I am curious, and it actually comes from some of the comments that have been made here. Does your agency, do you think congressional intent is important?
Absolutely.
In terms of doing that? Given that, the NPRM states that one of DOL's goals is to promote parity between agriculture and non-agricultural exemptions. Can you tell me where in the originating statute or any subsequent amendments that have been made where Congress indicated that it wanted such parity?
I think the conversation about parity comes from the idea that that agricultural kids should be similarly, or workers and employees, agricultural farm worker employees should have similar protections as children who are employed in any other industry. So consequently, when the Congress made clear that we weren't going to give similar protections based on age to children who were employed in agriculture, because for kids who are employed in agriculture, they cut off any kid over the age of 16 can be employed to do anything. Okay. But Congress, in the amendments in 1966, made clear that it was its expectation that the Secretary of Labor would identify that work that was particularly hazardous for children in agriculture to perform. Therefore, we can talk about, I guess, we don't necessarily, it's not a mandate of parity, but the idea being that when we're updating these regulations, we should be looking at the hazard as a hazard. And if it's too dangerous for a child to perform, it doesn't really matter whether it's in agriculture or in another industry if it results in the same risk to that child of serious injury or death.
That begs the question, why weren't the enforcement actions and actions on enforcement disclosed in the rule? What's going to be the fine? Who's going to enforce it? How much is it going to cost?
Well, actually, we have a portion of the chapter that does discuss the imposition of civil penalties. And again, that was an effort to make transparent and to allow for comment on how the agency is would be issuing civil penalties. And so, regulations are really there to implement and interpret the law. And so consequently, that's what's, put in a proposed rule. So I guess I'm not understanding that maybe you could repeat your question.
Well, I'll tell you, I guess because I want to be able to move on and be
Sure.
respectful of your time and our other panel as well. I guess one thing that greatly concerns me is you keep talking about the family farm.
Right.
But you ignored, in my opening statement, we've got great-grandma and grandpa's farm, grandparents' farm, our best friend's farm down the road, to be able to get them involved and for those children to actually to be able to get to work. So is this government trying to micromanage what has been a traditional method of neighbors working with neighbors, family members working with family members, and you're going to define what a family unit is and limit it to that?
Well, the statutory, Congress enacted and there's a lot of legislative history that talks about, how this new regulation or this new statute was going to protect children, and taking into consideration as expressed in the congressional history, the family farm. The way it's articulated in the legislative history, the purpose of the parental exemption, which is the language. This is not regulatory language. This is statutory language, which is that a child employed by their parent on a farm owned or operated by their parent was, based on the legislative history, the effort of Congress to acknowledge the family farm and the opportunity for children to work on their family's farm. So what the Department of Labor is doing its best is to apply that statute, and of course, and the intent, as we understand it, of Congress, that parents were perceived, which I would absolutely agree, I'm a parent, are naturally in a position to look after the welfare of their children, and therefore the law should not go there to impinge on the ability of that parent to make good decisions on the behalf of their child. So now the task for the Department of Labor is to discern how best to implement the intent of Congress.
Okay, just kind of an opinion. I think that we ought to empower those parents as well to say they can go and pick corn.
Okay, and we're, Congressman, this is another area, as you know, because we're reproposing the rule, where the agency has received significant comments. The idea of reproposing the rule was to be able to be certain that we can take full consideration of just the concerns that you just raised.
Okay. Congressman King, thank you.